Well, hello. This is Brian Benkstein. I'm an attorney at Frederickson and Byron, and welcome to Terminations Got You Down, 5 Tips to Tighten Your Termination Tactics. Before we get started substantively, I'll spend just a couple of quick minutes here giving you a little bit of background about me. I'm an attorney in the Labor and Employment Group here at Frederickson, and I practice in the area of defending employment-related litigation and providing advice, just like the kind of information that we're going to be talking about today. I'll advise on terminations, discipline, and other things that relate to the employer-employee relationship. I'm relatively new to Frederickson. I joined the firm in September, but I've been practicing in this area my entire professional career. I've been at a couple of other firms here in the Minneapolis area. And prior to becoming an attorney, I was a manager in the healthcare industry. I held a variety of management positions. And so some of the information that we're going to talk about today is really drawn upon some of my personal experiences in management. And I can say with all candor that I feel your pain. Dealing with these kinds of situations can be difficult, and what I've attempted to do with these materials is to, again, draw upon that personal experience in the trenches, so to speak, and combine that with the things that I see or have seen over the years in defending various claims on behalf of clients. And really, what I'm hoping that you'll get out of this presentation today are some practical tips that you can apply in your day-to-day places, organizations, that will help you avoid liability when you do have to go through the unfortunate step of terminating an employee. Just a couple of quick housekeeping issues. I understand that in terms of asking questions, you can do that by the chat feature that's associated with the webinar. And what you need to do is hover over the bottom of the screen. And when you see that chat feature, you can submit a question that way. And the way that we're going to structure this this afternoon is that if you want to go ahead and submit your questions, we're going to save those questions until the end. I've got some time built into the presentation to be able to answer at least some of those questions. So go ahead and send those via chat, and we'll talk about them more substantively at the end. All right, in terms of the substance, here we go. And setting the stage, here's what we're trying to accomplish here in the next 45 minutes or so. What we want to do is to avoid turning a legitimate termination into a risky one by following some, what I would characterize are some pretty easy best practices. And just so that I'm not going to disappoint you, this presentation is really not heavy on the law. What we're going to be talking about here this afternoon are some, again, really practical things that you can keep in mind and hopefully implement in your organizations. And really, the drift here is that once you've made a legitimate termination decision, what we want to do is make sure that you're putting yourselves in the best possible position to avoid litigation and exposure, because unfortunately there are some things that you can do during the termination process or in connection with the termination process that really can create exposure. And that's where we're talking about avoiding turning a legitimate termination into a risky one. And it's really through making some missteps along the way. And that's what we're going to try to focus on here, and hopefully you can avoid. So what we're going to do, we're going to focus on what I call the 5 tips. Tip number 1, honesty is always the best policy. And I'm going to talk more about that, and that may seem self-evident, but it's absolutely critical that whenever you're making a termination decision, that it's predicated and rooted in honesty, and that flows to what you ultimately communicate with the employee and others in the organization, and potentially even third parties. Tip number 2, we want to plan ahead. There really shouldn't be a circumstance in which an employee is being terminated at a whim. I'm going to tell you a horror story when we get to tip 2 about where I didn't follow my own advice and where it led to some problems. So we want to definitely plan ahead, make sure that we've got our ducks in a row, so to speak. Tip number 3, no missteps on the logistics. This relates to really focusing on some of the fundamental legal requirements that relate to the termination process, and namely the timing of the last paycheck, making sure that you're not taking inappropriate wage deductions from a final paycheck, and more to come on that point. Tip number 4, don't lose control of the termination meeting. The termination meeting in tip 4 really is in part related to tip 2, and that is you have to plan ahead. There really shouldn't be a circumstance in which you lose control of that termination meeting. We're going to talk more about that, obviously, but it really goes to the point that you as the employer need to retain and maintain control of that termination meeting in the process. Because if you get drawn into a discussion or a debate with the employee during the termination meeting, it tends not to go well. Tip number 5, accurate and strategic documentation, underscore on strategic. There are things that you can do with respect to the termination-related documentation that puts the organization in a much stronger and more defendable situation to the extent that you are faced with a claim or a challenge or a complaint or a lawsuit down the road. So we'll talk about that as well. So tip number 1, honesty is always the best policy. What I always suggest with my clients is that you work backwards from the employee's anticipated request for the truthful reason of termination, for termination. In Minnesota, an employee has the right to request in writing within 15 days following termination that the employer has to say, you need to tell me and you need to give me the truthful reason for my termination. So as a result of that legal requirement, you should always anticipate that the employee is going to make that request. So we always want to start with what is the fundamental, honest, and truthful reason for this employee's termination. And if you start at that launch point, everything will fall into place. Whereas if you don't have an honest and legitimate reason to begin with, well, we have a problem. Just by way of the logistics, an employer is obligated to respond to one of these so-called truthful reason for termination requests within 10 working days of its receipt of any such request. And I've got the citation to the relevant Minnesota statute, 181.933. I sometimes will get questions, well, going back a step, well, what if the employee doesn't ask me for the truthful reason within the 15-day requirement? What if I don't respond within the 10 days? Well, as it relates to the request component, and that is, let's just say an employee is 1 day late in making that request for the truthful reason. Should you deny the request and just simply refuse to respond? The answer is absolutely no. We don't want to rely upon technical defenses as related to the statute, and I really can't see a good reason for doing that. So if the employee makes that request for the truthful reason, and even assuming it's late, even assuming it's verbal as opposed to written, just go ahead and respond. In terms of the deadline to respond, you definitely want to comply with that deadline. Is it going to put you in an indefensible position if you don't respond within the 10 days? No, not necessarily, but we want to always send the message that we're on our game, so to speak. And if the statute requires that you respond within 10 days, then we respond within 10 days. I always like to get these responses out within a week's time, just to give ourselves a little wiggle room. And then I often get questions along the way of, what's the best strategy in responding to one of these so-called truthful reason for termination requests? And you can talk to a number of different employment law attorneys, and you'll get probably an equal number of answers. But they'll fall within kind of the school of thought that general is the best. Others you may talk to will say, boy, you really got to get specific and drill down into the details. I fall into the school of thought that general is absolutely the way to go. The reason for that is that I think that there are things that can come up, and despite the fact that you may think that you're completely prepared, you have all the information that you need to render a termination decision, I'll challenge you that something always seems to come up. I've had clients that I've defended in employment-related litigation that have gone down the road of providing a really long and specific, detailed response. You've been terminated for the following 10 reasons, and it goes into excessive detail. And at the time, the employer thought that was the best strategy. What I don't like about that is that it ends up exposing the employer to cross-examination down the road. So, for example, if you were to get sued and you have a truthful reason for termination response that goes into explicit detail, those are all areas that a skilled employee attorney is going to subject the employer to cross-examination. So to that end, I always like to go the more general route. To be clear, it has to be honest, but can it be something along the lines of you are being terminated because you have failed to meet our expectations? That's a perfectly truthful reason, and it satisfies the statutory requirement. Can you be more specific and say, you are being terminated because you violated the company's policies? Of course you can. And I think that if you feel like you need to get into more detail, really ask yourself whether it's necessary. Because I think that it puts you in the best possible position as the employer to defend yourself down the road if you provide that more general response. So that's again, I think the way you should go on that. But if you feel that there's a specific circumstance and where you need to dive into more of the details, there are certainly circumstances where that may be appropriate. But I think leaning more general is definitely the best practice. So here's, I would say, the most important slide with tip number one, and that is this. If the truthful reason for the termination is not legitimate, then you need to rethink the decision itself. And I'm going to give you an example of that in a minute. If the truthful reason is inconsistent with the employee's personnel record or other business records, then you should reevaluate the reason. And I underscore or underline those two concepts because there's a critical distinction there. In the first instance, if your termination reason is not legitimate, you shouldn't be terminating the employee in the first instance. However, it's possible that you may have, you've reached a decision to terminate someone, you've developed your reason for it, and lo and behold, it's just not consistent with other information that's out there. And I'll give you a couple of examples to drive home the point, hopefully. So example number one would be the manager wants to terminate the employee because of frustration with intermittent FMLA leave. Well, that's a situation where that is a patently unlawful reason to terminate someone. And as a result, that employer needs to rethink the termination decision as a whole. If, on the other hand, employee is being terminated for historical poor performance and repeated instances of misconduct, yet the employee has a spotless or what I would say perfect personnel record, well, then that's a problem too, because our reason is just simply not consistent with the employment-related records that go along with it. So in that second example, does it mean that you have to withhold or withdraw the termination? No, but this might be a circumstance in which you're not going to characterize it as historical poor performance, but instead performance over the last 3 months, performance over the last 6 months. performance as related to a specific incident that happened in the last week or two. Those are all, again, perfectly legitimate reasons to terminate someone, and they would not be, in those examples, inconsistent with a spotless personnel record. If you have an employee that's being terminated for performance issues, you need to say exactly that. I've had a number of employer or clients along the way and over the years that will sometimes rely upon the so-called downsizing or job elimination argument, even though it's not true. And I think the reason why I've had clients that have done that because they're trying to let the employee down easy. The employer thinks it's better to let somebody know that we're eliminating their job or downsizing instead of just coming right out and saying you're being terminated because your performance is not very good. Although it's difficult to tell someone that, you owe it to the employee and, in fact, the organization to be honest. And so if it's a performance issue, you got to say that. You can't characterize it as something that it's not. This is hopefully I'll get a chuckle, and I guess if you can send me a chat if you think this is mildly funny. But at all costs, avoid the logically inconsistent Minnesota nice, let them down easy approach, and that would be termination meeting. The manager says to the employee, in all honesty, you're the greatest, and we'll always think that. We love you, and you love us, but I think we can all agree that things just aren't working out. That's obviously made up, but I've unfortunately had cases where the employer has said something similar, notwithstanding the fact that this employee was a complete train wreck. The employee was a terrible performer, absolutely positively needed to be out of the organization, but yet we take them down the road of the Minnesota nice, passive-aggressive, dishonest answer. Or dishonest reason, I should say. So again, avoid that at all costs. All right, tip number 2, planning ahead. And I would say that, of all the tips, don't underestimate the importance of planning ahead. An employee's termination needs to be carefully coordinated. It goes without saying that you want to make sure that your IT function is looped in. You want to be protecting your email, network, servers, important business documents, whether that's on a network server, a desktop, a company-issued phone, etc. Although it's uncomfortable, perhaps, to deal with these kinds of issues, and it's also important that whoever you're connecting with in IT is a person that can obviously be trusted, and they're not going to let the news leak out that an employee is going to be terminated. But we really need to be on top of this stuff because employees, again, facing a difficult situation, will sometimes lash out by taking company documents, sending themselves company emails. And those are things that we just need to protect ourselves against. And so the best way of handling that IT piece is to, again, and it has to be very carefully coordinated, is to let your IT function know that you're going to be meeting with an employee at X time, and that as a result of that conversation, the employee is going to be terminated. And so you want IT to put a hold on or block access to the email and other company information, as that employee is heading into that meeting. Unfortunately, the risk there is that if you have a misstep and IT turns off the email or denies access too early, well, guess what? That certainly sends a message to the employee as to what might be coming. So again, underscore the fact that it needs to be really carefully coordinated with respect to timing. Some employers that I work with like not to get into those kinds of details and simply will turn off the email when they get word from the manager that the employee has in fact been terminated. So it's really up to you how you want to handle that, as long as you've addressed the issue. Obviously, you want to get have the employee return keys, access badges, those kinds of things. It's never, from my standpoint, never okay to simply let the employee walk out with any of these things with the promise that they're going to return it tomorrow or the next day or the day after. Once an employee's been terminated, we need to make sure that we've in effect locked down the company's information, documents, and obviously its property as well. Another part of planning ahead is how will you communicate the decision to other employees and respond to questions. Oftentimes, it's just something that employer's not thinking about, and the problem can be, number one, it puts you, the employer, in an awkward position. Someone approaches you and said, "Gee, what happened to Jane? What happened to John?" And you don't have a good prepared response, or in fact, you don't have any response. I think relatedly, the other problem from a risk standpoint is that if you have different managers or leaders communicating different messages about why an employee's been terminated, it can expose the employer or the organization to risk, because it goes to the issue then of, well, what is the true reason? If we have manager A saying one thing, manager B saying another, another senior leader saying something completely different, those are all things that are not helpful to you as it relates to exposure and potentially defending yourself. You also need to develop a communication strategy for external third parties, customers, clients, other people. That's especially important when you have an employee that's forward-facing, a sales representative, a manager, something like that. So don't leave those things to chance. Those are things that you can be proactive, and you need to make sure that you're potentially the lifeblood of your business, and that's your customer relationships, are also taken care of, and customers know that Jane or John is gone, and that they have a new point of contact, and that the company's going to take care of them. Another part of the planning process is to think through the timing and location of the termination meeting. Again, something that's oftentimes overlooked. And really what you want to be focusing on is what will cause the least amount of disruption to the work environment. What's the best approach in maintaining the employee's dignity? That's also a really critical factor. Oftentimes, employees will lash out and sue their former employees when they feel that they've been, quote unquote, disrespected or treated poorly during the termination process. And again, I would venture to guess that basically all employees are not going to be happy about being terminated. But if you strip someone of their dignity in the process, that can certainly lead to increased risk. But the reason why I bring this point up is that oftentimes what's the best or the best strategy for protecting the organization is not what the manager or the person communicating the termination message would like to see. And what I mean by that is that if I'm going to terminate someone, I'm going to probably want to try to get it done as soon as possible to begin my day if I have to do it on a particular day. Well, that's probably not the best strategy, because then what happens to that employee after they're terminated? Well, they have to potentially pack up their stuff in front of the whole office. They have to kind of parade themselves through the office to leave. So definitely end of day, to the extent that it can be done even after hours, that's even better, because then it allows the employee to pack up their belongings and collect themselves without having to go through that, in effect, the parade themselves through the office. All right, tip number 3, no missteps on the logistics. And this gets into the what I would say are the technical legal requirements that relate to the termination process and the termination meeting. And this is about as heavy as it gets from a legal standpoint, so just bear with me. But these are some important things that you should be mindful of as you're going through the termination process. So first and foremost, payment of final wages. Under Minnesota law for private employers, the employee is entitled to receive their earned and unpaid wages, quote unquote, which are immediately due and payable upon demand of the employee. And this, to be clear, this relates to employees who are terminated, discharged employees. So the way it works, if an employee makes a demand, you as the employer need to pay those final wages within 24 hours after demand, otherwise you're in default. I've got reference here to the relevant Minnesota statute, and the problem is that if you don't meet that deadline, you can be exposed to certain penalties and ultimately attorney's fees if an employee were to sue you over this. So, and again, in most circumstances, hopefully it won't be a problem to get that final paycheck cut within 24 hours after a demand. But what I have a lot of clients do that I think makes really good sense is that they simply have that final paycheck ready to go for the employee at the time of the termination meeting. So as part of the termination meeting, you simply hand them their final paycheck, and this issue is basically taken care of at that point. I also get questions from time to time where employers don't engage in that practice. They don't have the check ready, and they receive a verbal demand for payment. And I've had clients that have, I guess, been confused or questioned whether they need to satisfy that 24-hour requirement if it's simply a verbal demand. I've looked at the statute closely, and I think it's somewhat unclear that you can avoid the 24-hour requirement if it's just simply a verbal demand. So what I tell all my clients, and I think it's the best practice, any kind of demand for payment that you get, whether it's verbal, whether it's in an email, whether it's in a text message, pay it within the 24 hours and you're done. There's no good reason to risk exposure under the statute, particularly with the attorney fee component, to I guess get into the nuance about whether it's a legitimate demand or not. Different rules apply to employees who quit or resign. When an employee quits or resigns, the final paycheck is due in effect during the processing of the next regular payday. There are some issues that can arise here, though, in a circumstance where you have an employee and let's just say that you meet with that employee and you give them the opportunity to quit in lieu of being terminated. And I've had clients ask that question. Well, gee, does that then put the employee in this other statutory provision where we can go ahead and pay on the next payday? I wouldn't take the chance. To the extent that you are dealing with an employee who you are letting quit instead of being fired, I would go ahead and make the payment within 24 hours after demand if they demand it. I also have questions that come up. Well, I've got an employee who quit or resigned. They're requesting their paycheck before before we run our payroll again. Is it okay to pay it? Of course you can. You can pay that final paycheck whenever you want. And I also have employers that anytime someone, it's going to be their last day, whether it's a quit, a resignation, whether it's a termination, they just simply have the paycheck ready. And I think that's a good, strong practice. And then you don't have to worry about the timing. You just simply have it for them on their last day. Just a quick note here. I'm not sure if folks in the audience have employees in Wisconsin, but some different rules apply in Wisconsin. And really, it's similar to Minnesota in that payment is to be made on the next regular payday, but it's for both employees who quit or are fired. So bottom line, Wisconsin employees, whether an employee quits or they're fired, you are obligated to pay them with the next regular payroll. Does it mean that you have to wait? No, you can issue the paycheck early if you want to, but Wisconsin gives employers a little more wiggle room to get that final paycheck issued. There's one notable exception though under Wisconsin law, and that is when an employee is separated as a result of, say, a merger, a liquidation, the business is closing, relocating, then employees must be paid within 24 hours, as is the case in Minnesota with a discharged employee. Unlawful deductions from wages. I say Minnesota employers must be wary of Minnesota statutes section 179. Be wary. Unfortunately, I still have a number of clients in situations that I deal with where employers are making unlawful wage deductions. And this statute applies to paychecks generally, but it applies with equal force to a final paycheck. And so Minnesota law states that employers are prohibited from making any deduction, directly or indirectly, from the wages due or earned by an employee for things such as lost or stolen property, damage to property, or to recover any other claimed indebtedness. And really what that means is that to the extent that the employer owes an employee, or an employee owes the employer money for something, and I'll use the easy example, we issued you 4 flash drives at the beginning of your employment. You lost all of them. We're going to deduct the cost of those flash drives from your final paycheck. Well, under Minnesota law, you can't do that. You can't make a wage deduction unless the employee has authorized you to make the deduction after the loss has occurred. And I'll explain what that means in a moment. Here it is. So the only circumstance in which you can make a lawful withholding from someone's final paycheck is after the loss has occurred and after the employee is indebted to you for whatever that is. The employee voluntarily authorizes the employer in writing to make the deduction. So we'll go back to my silly flash drive example. So let's just say an employer issues the employee 4 flash drives at the beginning of employment. Employee loses all of them. At the point in time where the employee is leaving the organization, whether either quitting or resigning or being fired, the employer says, hey, remember, we issued you those 4 flash drives. You need to reimburse us for those flash drives, and we want you to voluntarily authorize us to withhold that money from your final paycheck. If the employee agrees to that and agrees to do so in writing, the deduction is lawful. However, if the employee says, no way, I'm not signing it, you can't make me sign it, I'm not going to pay for those stupid flash drives, you're stuck. You cannot go ahead and just simply make the deduction. And you also can't make that deduction even if, for example, at the beginning of the employment, the employee said, I know that I'm responsible for all the flash drives that have been issued to me. I hereby authorize the employer to withhold money from my paycheck for the flash drives if I lose them. The reason why that doesn't work is that under the statute, prospective waivers like that are not allowed. And getting into a little bit more detail, the reason for that is that at the time that employee signed that prospective waiver, the so-called claimed indebtedness hasn't arisen yet. So as a result, that prospective waiver is invalid. So this is an area that, again, I think that my advice to employers in the state of Minnesota is that you really should avoid wage deductions unless it's really something significant. And it's something that you make sure that you're following to the letter, the statute. I've had clients that have been faced with these situations, and for example, sometimes it can involve issues that are significant. Employer issues the employee a laptop, and let's just say it's a $3,000 laptop, and the employee won't return it. And that's generally where I get a lot of these questions when we're talking about a high dollar amount item. Well, there are other ways that you can collect that or recover that piece of equipment. There's small claims court. There's other forms of legal action. You can have your lawyer draft a nasty demand letter, or not nasty. You can write your own demand letter. There's other things you can do aside from trying to withhold that money from their final paycheck, because I can tell you that time and time again, I've had clients that have just gotten this wrong and in effect goofed this up, and it exposes them to unnecessary risk and liability. Tip number 4, don't lose control of the termination meeting. And this is a biggie. It's absolutely essential that you, the employer, don't lose control of the termination meeting. You're the one that controls the message, the timing, the location, and the attendees. I have in brackets for the most part. On that point, if you are in a unionized setting, different rules apply. An employee is entitled to have a union representative with them, or even another representative with them. Sometimes employees will say, I want a witness to the meeting. Well, in general terms, I will allow, or I tell clients that that's okay, so long as the employer has a witness there too. Certainly the employer doesn't want to be outnumbered at a termination meeting. But if you have questions or concerns about whether someone should or shouldn't be allowed to attend a termination meeting, or a disciplinary meeting for that matter, and it's outside the union context, it may be appropriate to get some advice on how to handle that. But what's clear is that an employee's mom doesn't get to come to the termination meeting, a family member. I've actually had that come up where I've had clients say, Jimmy wants to bring mom along to participate in this meeting. The answer is absolutely not. Same holds true with an attorney. The employee wants to bring their attorney to this meeting. Absolutely not. There should never be a circumstance where we're allowing an employee's attorney to sit in on a termination meeting. So when you're in the termination meeting, in the termination process, it's essential that, and this may be evident and obvious, but you need to be confident about the termination decision, and you can't waffle. You've done your homework, you've checked your facts, you gave the employee a chance to tell his or her side of the story. You've concluded that the termination of the employee is legitimate and it's in the best interest of the organization. The termination meeting is not the time to either actually waffle or create the impression that you're waffling about the decision itself. You've made the decision. The purpose of the termination meeting is to go in and communicate that decision that's already been made. To the extent that you look insecure, not confident, it leads to risk, because the employee then thinks that you're up to something. The employee thinks that the termination is not legitimate because you look like you're shaking in your boots and you're not confident about the decision. How do you communicate the message? Well, absolutely do not do the Minnesota nice passive aggressive let them down easy approach that I talked about earlier. You need to be direct, and you can be compassionate, respectful, and direct all at the same time. There's no in terms of communicating the message, you can be direct and honest and do it in a polite and respectful and professional way. It goes without saying, of course you can. And you need to definitely determine what you want to say in advance. There should not ever be a circumstance where you're going into a termination meeting in effect winging it. No good comes out of that. At a minimum, you should create talking points that will guide the conversation. The reason why I say talking points are important is that it's easy to get off track. A termination meeting is not easy, and no matter how many times you've terminated an employee, it's not easy. It's stressful, and to the extent that you don't have talking points in front of you, I think it exposes you to risk, because you may end up saying something that you didn't intend to say, or you may not cover something that you really need to cover. The main reasons for the termination must be addressed. And if you have concerns about staying on task, it's certainly fine to script the message. I have certain clients that I work with that know that they get nervous when they're terminating an employee. They know that they have concerns about their ability to stay on task. So essentially what we do in those situations is that we go ahead and prepare the truthful reason for termination letter that I talked about earlier. And the employer representative just simply reads it to the employee and hands them a copy. What I don't like about that is I think it makes the termination a bit more impersonal, but given the unique circumstances with some of my clients, it's much better to script the message and say exactly what's on paper, as opposed to freewheeling it a bit and potentially saying something that you're going to later regret. What if the employee attempts to engage in a debate about the merits of the termination decision? Avoid at all costs. Do not take the bait. There are unfortunately employees out there who will attempt to use the termination meeting as a method by which to cast doubt on the termination decision. It's possible that an employee may be trying to set you up. I've had that happen before. And so when you're engaged in that termination meeting, delivering the termination message, now is not the time to be debating with the employee about whether the termination is legitimate or not, whether the employer was right or wrong, whether the employer was fair or not fair. Your job is to go in and communicate the termination decision, and you want to do it as efficiently as possible. To that end, how long should the termination meeting last? Well, I can tell you, definitely not an hour. I had a client who called me within the last 6 months, and we were talking about the termination. And when we got to talking about how the termination meeting went, the client proceeded to tell me that, boy, it was a really lengthy meeting. The termination meeting went on and on and on. And when I asked, how long was the termination meeting? Well, it was over an hour. I love this client dearly, but a termination meeting should never, ever, ever last an hour. A termination meeting should last on average 2 to 3 to 4 to 5 minutes. You want to get in, you want to get out, you want to communicate the message, but don't get involved in that, engaging in the debate, discussing all the aspects of the employment. The decision has been made. It's time to communicate that message efficiently and move on. A question comes up oftentimes, actually. What if the employee wants to tape record the meeting? They sit down at the meeting, put a tape recorder in front of the employer representative, hits play, and says, okay, what do you want to talk to me about? Well, in Minnesota, and I think it's a really stupid rule, it's lawful for someone to or record someone so long as one person is aware of the recording. So in other words, even assuming the employee had a tape recorder running in their pocket that you don't even see, that's okay. And what I tell employers is that, always assume you're being tape recorded anyway. If I don't think that in that circumstance, if that employee sets the recorder down and it makes you feel uncomfortable, if you feel like you're rattled as a result of the employee doing that, you can always suspend the meeting and decide what you want to do. But again, if you follow the advice that I've laid out earlier, and that is you've planned ahead, you know what you're going to say, you've got your talking points and or your scripted message, it really doesn't matter whether you're being recorded or not, because you're ready to go. So again, it's easier said than done sometimes. And I can say that, if I was in your shoes and getting ready to terminate someone and someone plopped down a recorder, it would make me uncomfortable. So again, there's no reason why you couldn't suspend the meeting at that point. Get yourself collected, get legal advice if you need to, and then you can make your plans accordingly. To that end, under what circumstances do I suspend a termination meeting and potentially reevaluate the decision? Well, use your good discretion and judgment. But what I would say, and here's an easy example, you're getting ready to terminate someone for some poor attendance. Lo and behold, the employee says, well, I've been asking my manager for an FMLA leave as related to XYZ medical condition for months, and my manager just hasn't responded to me. Well, unless you know the circumstances well enough to know that assertion is just simply untrue, that might be an instance where you suspend the meeting, you reevaluate what's happened, conduct additional investigation, and you come back and deal with it. Again, and this is a fine line to run, in that oftentimes an employee, as part of that attempt to debate with the employer, will try to bring stuff up to throw you off track. Again, most often it's not something that should cause you to deviate from your plan, and that is to go in and terminate. But there can certainly be circumstances where it's appropriate to reevaluate to make sure that you're making the right decision. I just gave you that example, so we're going to move on. Tip number 5, accurate and strategic documentation. Well, first of all, you know, I understand in the pace of today's work environments, documentation takes time. You're pulled and tugged in all kinds of different directions, and documenting a termination meeting is maybe the last thing you want to do, or you just simply don't have time. Please understand, though, that your attention to detail when documenting the termination meeting and the reason for termination is critically important if you ever have to defend yourself. And that is, written records make up for poor memories. And it's something that will help you 2-3 years down the road remember what you talked about. Documents have evidentiary weight. It's far more persuasive when a person on a witness stand says, here's what happened during the meeting, and here's why I know that happened at a meeting, because I have this document that summarizes it. And so for that reason, termination meeting documentation should be strategic. You want to envision that document potentially being used as an exhibit at trial, and hopefully that'll never happen. But you want to make sure that you're again putting the appropriate amount of time and attention into the document so that you can use it effectively and strategically to protect the organization. How do you document the termination meeting carefully? I'll give you a quick nightmare example. I had a case I defended. 2 employer representatives attended the meeting. Their notes from that same meeting that they attended were a complete and total disaster. We had one manager saying the meeting occurred on one date. We had another manager saying it occurred on another date. We had one of the managers taking notes indicate that there was a third part, or rather a fourth party present in the room. My other manager didn't have that down and couldn't remember. We had a number of inconsistencies as to who said what and how the meeting played out. And unfortunately, for my client, a lot of the inconsistencies related to things that really weren't that relevant, and it really didn't go to the legitimacy of the termination decision itself. But what ended up happening is that conflicting documentation was used by a very skilled employee attorney, and he made my 2 manager representatives who attended that meeting look like buffoons. They looked like they didn't have their act together. It looked like they were being dishonest about things when they really weren't being dishonest about things. So that employee attorney completely twisted things around in a way that created exposure for us simply because the note-taking was sloppy. So as a result, documentation of the termination meeting, it needs to be, goes without saying, complete and accurate. You got to capture the main discussion points. Always, always, always describe the reason for termination. In that example I just gave you, I had one manager that described the reason for termination that was just inconsistent with the other reason that was written down by the other manager. And then the employee's response. You should always try to capture the employee's response as carefully and as objectively as you can. And so, for example, if an employee says in a termination meeting, you got me, my performance is objectively poor, and I've been slacking off for years. Guess what? Not only do you want to write that down, put it in quotes. Something that you put in quotes is far more persuasive in a trial situation than simply saying employee admitted to his bad performance. Well, what we have here in the slide, if that's truly what the employee said, that's far more persuasive, not only because it's in quotes, because it's in a lot more detail, and that would help us. So in kind of breaking this down, definitely you should have 2 employer representatives at a termination meeting. And that it only makes sense to help protect the organization. However, only one of those managers should be assigned the job of taking notes. However, the second manager needs to review those notes once they're completed to make sure that they're accurate. So then we've got both of the managers absolutely on the same page, making sure that those termination meeting notes are in fact accurate, and they can both say that they're accurate. Finally, when should the termination meeting be documented? Again, with the caveat that I understand you're busy, things are going 100 miles an hour, sometimes more. The best practice is to just complete that documentation, certainly by the end of the same day, but preferably take the time at the end of the actual meeting to document it. To the extent that both managers you had two managers in the room, sit together, come up with the documentation, and then you're done with it. Because I've been in circumstances where I haven't followed my own advice, and after a termination meeting, I put it on the to-do stack, and lo and behold, 2 weeks later, I'm going back to that and trying to complete it, and my memory is faded because of all the things that have happened in the last 2 weeks. So, and again, I think it's human nature. The longer period that goes on between the termination and the documentation, not only is there greater risk of inaccuracy, but you're just not going to be able to paint the same kind of picture because you're further from the moment. All right, I've got a couple of questions here that have come in. And the first one is relates to I think the improper deduction from wages. I'm going to read the question. What if an employee signs a loan agreement for a scholarship and then quits? Employee signed, employee signed gets the dollars they will deduct out of the final paycheck. If they leave before 3 years is up, and how do we handle a situation like that? Well, I can say that there are some exceptions built into the statute for loan agreements if they're truly a loan agreement. And so in that circumstance, there are ways that you can potentially recover that money from a final paycheck, but it's subject to limitations. And to the extent that you have a circumstance in which you're trying to recover loan payments, and part of the way that you're going to try to recover it is through a deduction from a final paycheck. I'm not here to an ad for myself or our firm, but you need to get advice on that because things can go wrong. And the reason why I say that is that there are also limitations built into the statute that the deduction that you ultimately make can't be more than certain limitations on garnishment under Minnesota law, which frankly is just a completely convoluted set of statutes. So all a long way of saying, in summary, there are definitely ways that you can collect on a loan agreement, but I oftentimes advocate for a different process to collect that money as opposed to trying to do it from a final paycheck. There's a question on documentation. Can one person write them up and both staff present read, agree, and then sign? Most definitely. I think that if you have, again, it goes to the point of having that note taker be one person and making sure that that second manager representative or human resources representative, as the case may be, just confirm the accuracy and sign off on it then. So yeah, I like that practice a lot, and it's definitely consistent with what we've been talking about. A question's come in, how long after being terminated does an employee have to file a lawsuit against the company? And I wish I didn't have to say it as a lawyer, but it depends. It depends on the particular statute that the employee is relying upon. If they're relying upon a statute, it depends on the particular statute at issue. Generally speaking, claims for discrimination need to be brought under federal law within 300 days of the alleged unlawful practice. In Minnesota, to the extent that an employee brings claims for discrimination based on the Human Rights Act, the Minnesota Human Rights Act, then an employee needs to bring that claim within a year. So generally speaking, rule of thumb, discrimination claims need to be brought within a year. There are other types of claims, for example, a whistleblower claim that's subject to longer, what are called limitations periods. So it really depends on the circumstances. And sometimes too, even though you think that you've got a clear line in the sand, there are mechanisms by which a court can extend those deadlines based on unique or unusual circumstances. But again, generally speaking, rule of thumb, year on kind of your traditional or typical discrimination claim, race, gender, disability, those kinds of things. And those are the questions that have come in. I really appreciate everyone's time this afternoon, and I hope you enjoyed the presentation.